What happens if I don't have a will in place?
If at the time of your death you do not have a last will and testament, then at that point, any assets in your individual name will have to go through what's called the laws of intestacy to determine the distribution by the probate court. Now, what I emphasize about the laws of intestacy, this is where the courts determine who they deem to be your closest legal relatives, and they are the ones that take. You have no say-so. You have no opportunity to support these charitable causes that were important to you during life, and you have no ability to ensure that the prodigal son or daughter is not receiving funds that will support unnecessary demons or improper actions that you disagree with. It is important for you to have control over your legacy. It is important for you to have a will. And for that reason, you don't want to pass without a will. Because then at that point, as stated, the courts will take control over where your assets go via what's called the laws of intestacy.
What are the steps required to create a will?
In the state of Georgia, there are various requirements that must be met in order to create a will. Number one, age. The individual creating the will must be at least age 14 or older. Number two, the individual must have capacity, meaning they must be of sound mind at the time of signing the will. Speaking of signing, number three, it must have a signature attached to it. And by a signature, affirming mark, or the signature of another at the instruction of the testator. Number four is that there must be witnesses that have both observed the signing of the will as well as signing off that they are of the belief that the individual signed it was of sound mind and they were not under any form of coercion or improper duress. Five, it must be in writing. In the state of Georgia, the will must be in writing, and being in writing, we want to make sure it's dated. Lastly, although a notary is not required, what I do emphasize, it is always important to have a notarized document attached to the back of your will, supporting that the witnesses believed that the individual was of sound mind and not under coercion at the time of signing, and that it was the testator's interest and wishes at the time of creating the will.